Thank y'all so much for joining us for our March Clear Up the Chaos. Amanda and Mitch and we have pre-recorded this, not knowing what everyone's spring break plans look like. I felt like this was an opportunity this month for everyone to kind of watch it on their own time. But a friendly reminder, as a client of NCW and Sanford and Tatum, you have complimentary access to the Ironwood team for telephone support. And so if you haven't taken advantage yet of the wonderful team at Ironwood, I highly encourage you to sign up and get that paperwork back to me. You can always reach out to me by email or phone, and I would be happy to send that over to you. But I'm going to be handing things over to Amanda. She's going to be speaking on several different regulations that we've seen changes to. So we're excited to hear about that, and I'm going to pass things over.
Thanks, Elizabeth.
Thank you.
It is, in the world of HR, has been a very exciting few weeks. So we don't see so often a lot of major changes to the official wording of regulations and laws. And if we do, we normally have some notice. But like we've talked about before, what we're more likely to see is different rulings, whether it be through a board or through an opinion letter or at the local or state level. And through those rulings, we're able to kind of interpret the regulations a little bit more clearly based on where the trends are going. And that's all three of the things that we're talking about today. They're different agencies and different departments, but they're not necessarily new standards. They're variations in the interpretation and understanding of those standards. So we've got three pretty big news-making items. The first one I'm going to talk to you about is actually severance agreements. There's been some new limit requirements added. And I will tell you very honestly, if you see me thinking, it's because I'm trying to make sure I'm saying severance agreements and not separation agreements, because they are generally different things. Generally, a severance agreement is set up at the beginning of employment. You're doing that with your new hire paperwork. Separation agreement is going to be those that are offered when you're actually separating or there at the end of employment. So you see me pausing, I'm making sure that I'm saying severance, because sometimes we use those interchangeably and they're not. And in this case, it really applies. But severance agreements are regulated under the National Labor Relations Board. So you'll hear me say NLRB or the National Labor Relations Act, NLRA. A lot of times people hear either of those and they tune out and they assume that we are talking about unions or we're talking about things that do not apply to everyone, but that is not the case. There are some groups of people the regulations don't apply to, but in general, it applies to most employers, even those without union employees. So a little bit of basics there. But under this most recent decision here in just the last couple of weeks, employers can no longer use their severance agreements with really broad sweeping terms where they prevent any ex-employees from talking about the work that they did there at the company or really criticizing the former employers. That's a lot of what we're going to see the board decision surrounding. So as we're going through these changes, there's kind of three periods of time we want to focus on, because this is another one of those things where we interpreted the law one way before 2020, 2023, there was a different interpretation, and now 2023, until the next time we change the interpretation, we're talking about something different. So as I'm jumping around, I'm going to try to be very clear about which period in time we're talking about. But if you tune out or have to take a call and hear me saying something contrary, I've probably switched time periods on you. But prior to 2020, there was a lot of restrictions about confidentiality and non-disparagement agreements. So prior to that, overall, severance agreements weren't unlawful, but the focus was really on the language within the agreement and the voluntary nature, that it wasn't required that employees necessarily sign these. It was entirely voluntary. And you're going to hear me mention the voluntary part as we go through time. So now, if an employer violates the act, they have done so often through asking employees to waive their rights. So broadly saying you can't talk negatively about the company, or you can't talk about this after the fact. You can't share this confidential information. These very sweeping, broad terms are the pieces of the agreement that have been changing throughout times. Again, prior to 2020, pretty strict regulations about what employees could waive. 2020 to 2023, the focus really went on no, employees have rights. This is a voluntary agreement. If they don't agree to it, they don't have to sign it. And now 2023, they've come back, not quite full circle, but a little bit more to the pre-2020 language, where they're saying, no, you can't really ask employees to waive all of their rights. It's too broad, it's too big of an ask. They feel like they're not able to get the benefits of the employment agreement with you, your compensation, your wages, whatever you've agreed upon in advance, if they don't sign. So that's what the back and forth pull has been. So the offer in itself is sometimes expected to deter employees from exercising their rights. And that's not only ex-employees. So again, because it's a severance agreement, these would be things the ex-employee can't do after they've left the company. So in recent years, the limits on free speech has become increasingly common. So those regulations were getting stricter and stricter about what you could not say after the fact. And that's also where this shift seems to be. They used to be not quite so detailed. And so that's where some of the pullback we're seeing is it got more and more broad, more and more specific things could not be said and were included on that list of things you couldn't do under the agreement. So you can't sign off on this broad release of language. You also can't sign off on refusing to discuss working conditions or participating in investigations. So most of the time, day to day, if we were talking about this on a call or discussing a handbook or policies in general, if we were bringing up the Labor Relations Act or the Labor Relations Board, most often, not the only reason, but I'm just going to be very honest and sincere, we see it as like a disclaimer in a policy of no part of this is intended to violate an employee's rights under the NRLA. And a lot of times that's things like discussing wage, like you said, discussing confidentiality, things like that. So there's normally a disclaimer in policies and in handbooks to say, in no way are we legally saying you cannot do that. And it's a bit of a catch-all workaround to make sure that you're not accidentally violating the labor relations. So there were two cases back in 2020 where they really honed in on the board appointed by Trump on the voluntary nature of the agreements. And so again, they really focused on it's voluntary. It's not actually affecting any of the pay or the benefits that that employee received because they're no longer there. They already received all of the terms of the employment agreement. They're not there anymore. You can't coercively force them to sign something after the fact. So again, how could that interfere with employee rights? Over time, here in this latest interpretation, what they are saying is, and coming around to, is that just because that employee who signed the severance agreement and left is no longer violating their rights, that could actually still affect the current workforce. So if I leave from a company, I'm under a severance agreement where I've waived sweeping parts of my rights. I can't say anything about the company. I can't discuss my wages. I can't discuss employment conditions. This would be extreme. That doesn't just affect me as the ex-employee because it could come back and negatively impact the people that are still there because no one talked about it. And the case that came up most recently actually came out of the COVID era, and it was 11 employees who were permanently furloughed. And a lot of times the agreements are put into place for these types of situations, and more specifically than just something like 11 employees, but huge reduction in forces, huge layoffs. It's preventing from a lot of negative press and blowback potentially coming upon the company. So the language that would no longer be appropriate, that was 2020 to 2023, and they're now saying would be statements in any of your agreements that required absolute confidentiality. A lot of times there would still be the line, unless legally compared. But again, they're saying that that's too broad. It's got to be more specific language than that. You can't just waive all of your rights. And also, this is where some of the confidentiality of what employees learn while they're on the job comes into play. And without going down confidentiality, non-disclosure road, another piece of the ruling made by the board would be in specific to what you could share about what you learned working at the company. So a lot of times when you're looking at confidentiality type agreements, the things that you cannot share are the pieces of information, the things you came up with, the knowledge, your thoughts, things that you came up while you were employed that you wouldn't have otherwise known if you weren't working there. So that's also some of the limitations. You can't just broadly waive your right to ever discuss those things, because it could be talking about employee rights, it could be talking about labor conditions, and you can't sweep it all under the rug. So the remaining protections for you as employers, if you do use this kind of agreement, is having a really strong disclaimer statement within there. If you have been using a standard form for the last several years, it is probably time to go back and look at it. Now, if you've had it for a really long time, you might have never made changes in here in the last few years, but it's time to go back and see specifically what the agreement prohibits and see how specific or how broad that is. And this is something that is a legal document. So we are always, of course, happy to answer general questions, but that is something you'd absolutely want to review with an attorney to make sure that the actual employment agreement, the separation agreement, the severance agreement, any of those legally binding agreements are accurate and true to the letter of the law now. Another thing to keep in mind is that these laws do differ state to state. So if you are doing work outside of Texas, or you have employees living or working other states remotely, you may also need to check with local regulations to make sure that the agreements and terms to what you can and can't ask employees to do after the fact are the same. Because even though this interpretation was released at a national level, there's still maybe some other regulations that are similar or might affect other components of this locally that might come into play. So you, as employers, as HR professionals, as HR, as other duties as assigned, you just want to make sure that you are understanding all of those and not violating anything local just because you're operating in a new state. We do actually expect some of these employee rights to continue in this arena, and we'll see how it comes out. You know, we've seen a lot of rapidly changing interpretations here, as I've mentioned, but more things that protect employees in general is the trend we're seeing right now. So again, if you have questions about this, I know this was an area we don't talk a lot about specifically, again, unless it's about a policy or about a handbook or just reminding you, oh, you can't forbid them from talking about their wages or something like that. It's an area we don't cover as much here, and it's a lot of change over the 3 different periods of time. So of course, if you have questions when you come back from spring break or next week, if you're viewing this on your normal second Tuesday, Mitch and I and the HR team in Ironwood will be around, and we'll be happy to try to answer anything we can about that. So with that, I am going to turn it over to Mitch, and I will talk to you guys in a bit.
Thanks, Amanda. So I know when you saw overtime, you're thinking it might have been related to the Department of Labor's overtime rule change that we've been hinting at over the last few months. Unfortunately, that is still pending. Sounds like we're looking at potentially May, but we'll see. However, there was a pretty big case recently involving overtime and exemptions. And since we get quite a few questions each month regarding salaried employees, we wanted to walk everyone through this ruling and discuss a few key lessons that you can take away from it. If you've been on a call with us regarding a salaried employee, you can guarantee you'll hear us ask if the employee is exempt or non-exempt. What that means is an exempt employee does not need to be paid overtime, provided they meet certain factors. And the case we'll be taking a look at today is a recent ruling that could potentially impact your business and how you interact with that. So the Helix Energy Solutions Group Incorporated versus Hewitt Supreme Court ruling came out on February 22nd. This is a huge case in the days following the ruling, is all over the HR news sources, which centered on whether or not a highly paid individual would be considered exempt or non-exempt. To give some context to the ruling, over a 3-year period, Michael Hewitt was employed as a tool pusher on an oil rig, working 28 12-hour days on and then 28 days off. And he was making upwards of $200,000 a year annually. So he's paid a daily rate between $963 and $1,341 per day. So while Helix had him classified as salaried and exempt, Hewitt and the Supreme Court disagreed. In their ruling, they determined that Michael Hewitt was not exempt and would be entitled to overtime for this period, and that paying an employee a huge salary doesn't automatically make them exempt from overtime. So to understand why the Supreme Court ruled against Helix, it's important to understand the 3 factors that go into determining exempt status under the Fair Labor Standards Act, or FLSA. First, there's the job duties test, in which an employee's duties must align with one of the 5 categories. So there's the administrative exemption, where an employee's duties involve managing a part of the business operations and requires a level of discretion and independent judgment. There's the computers exemption, where they're working in a role directly related to the application and design of computer programs or related systems. So things like a systems analyst, a programmer, software engineer, kind of those tech titles that you'll see in different job postings. There's the executive exemption, which covers employees that are involved in managing the company or a department with at least 2 or more employees they direct. And you also have to have the ability to hire, fire, and offer advancement opportunities. There's an outside sales exemption, which covers individuals involved in making sales or obtaining orders for services paid for by a client or customer that is regularly away from the office. So you can't just be sitting in the office. For the outside sales exemption, you do need to be going out, visiting client sites, interacting with customers, things like that. And then the final exemption is the professional exemption, which covers individuals working in the fields of science and learning that require advanced knowledge and training to perform the work, and that work does need to be intellectual in nature. So that said, there's also an exemption with highly compensated individuals. Currently, they need to be making over $107,432. And with that, they only need to meet one of the duties of an executive, administrative, or professional exempt employee. So a common mistake that companies make with this test is basing the exemption solely on job titles instead of the actual duties. For example, with the executive exemption, there's 2 prongs to the test. Just because somebody has the title of supervisor or manager doesn't automatically make them exempt. The employee must regularly direct the work of at least 2 or more full-time employees or equivalent, and have the authority to make hiring and firing decisions. These responsibilities must also be a primary duty, which means that the duty consists of the employee's main or most important responsibility. Someone who occasionally steps in and supervises one other person may not qualify for an exemption. So if you aren't sure whether or not your employees would qualify for an exemption, the DOL actually has a pretty handy tool on their website. It's the FLSA Overtime Security Advisor. And it allows you to go through each of the exemption categories in a step-by-step process to assist with ensuring your exempt employees are truly exempt. So the reason I covered that was in this case with Helix and Hewitt. Hewitt's role as a tool pusher met the necessary criteria of the job duties test under that highly compensated individual exception. He had supervisor authority over 12 to 14 employees and was involved in managing various aspects of the rig's operation. So he was covered under the executive exemption. Based on his daily rate, which was between $963 and $1,300, he satisfied the 3rd test, which is the salary level test, which provides kind of a minimum baseline for a weekly salary. Currently, it's $684 per week. So he's well above that. However, the 2nd test, the salary basis test, is what this case hinged on. So an employee will be considered to be paid on a salary basis within the meaning of this test if the employee regularly receives each pay period on a weekly or less frequent basis a predetermined amount constituting all or part of the employee's compensation, an amount which is not subject to reduction because of variations in the quantity of the work performed. So that's super wordy, but basically what it boils down to is the employee's guaranteed a weekly rate, regardless of how many days or hours they work. So the core issue was how Helix actually structured their payroll. What they did was, instead of specifying that weekly guarantee, they structured their compensation to be based on a daily rate, disregarded any sort of weekly guarantee. So he was paid a flat rate per day. If he worked 5 days that week, they'd take that 963, for example, multiply it by 5, and here's your weekly rate. So as such, by doing it that way, they did not meet the criteria for the salary basis test. I found a couple estimates on it. It sounds like the company could potentially owe him up to $600,000 in back pay, plus the employee's attorney fees, plus whatever fines will be levied as part of the ruling. I wasn't able to get a firm number on it, but that's just an estimate on it, but it's definitely a big chunk of change. So big expensive mistake, but in the Supreme Court's opinion, Helix could have come into compliance with the salary basis requirement for Hewitt and similar employees in one of two ways. It could either add to Hewitt's per day rate a weekly guarantee that satisfies the conditions of Section 604B, or it could convert Hewitt's compensation into a straight weekly salary for the time he spends on the rig. So Section 604B that they cited states that the company can provide a guaranteed weekly amount in addition to the daily rate, but that this weekly rate must be roughly equivalent to the employee's usual earnings at the assigned hourly, daily, or shift rate for the employee's normally scheduled work week. So basically, had they taken his daily rate, multiply it by the number of his usual days in the pay period, they could have just set that as, hey, this is your weekly guarantee, and called it good. The other option would be to simply just convert it into a weekly salary, and the entire issue could have been avoided. So why does this matter? Well, if you have a structure in place for paying employees on a day rate basis, it might be worth taking a look and kind of reassessing your pay structure to ensure compliance with the FLSA. Make sure you have those weekly guarantees built in, or consider transitioning to just a flat weekly salary to avoid failing that salary basis test. With that weekly guarantee, they work 1 hour, 1 day a week, they'd still be entitled to a full week's pay under the FLSA. That said, there are some potential options if you're worried about paying somebody a bunch of money for time that they're not working. So with the situation with a rotational schedule like Hewitt's 28 days on, 28 days off, you see 14 days on, 7 days off, different variations of it. Taking the time to make sure that their weeks align with your work week is an easy way to avoid having 3 of those days fall in 1 week, the other 4 fall in another week, and you're paying 2 full weeks for 2 partial weeks. So take the time, make sure it aligns to your work week, and you can mitigate issues that way. If they do miss work, there are a couple exceptions in place that would allow you to deduct days from that weekly guarantee. For example, if they miss work due to injury or illness, you can establish a bona fide sick plan here in Texas that could potentially allow you to deduct days in accordance with that sick time policy. There's a lot that can go into it. You do need to offer a minimum of 5 days of paid sick leave. You also have to have a signed wage deduction agreement in order to utilize the deductions, but it does give you a couple options for mitigating some missed time expenses. While you can't deduct time for jury duty, serving as a witness, or military leave unless they miss that entire week, there are potentially ways that you can deduct the fees associated with that if you take the time to really dig into it. For vacation time, if the absence is related to a personal reason, you can potentially deduct a full day. However, you can't deduct a partial day. So if somebody goes home, they just need to take a half day, you'd still have to pay them for the full day. But if they take a personal day off, you can potentially deduct that as well. So in short, with a couple tweaks, you can easily accomplish the same outcomes as you would using a day rate basis while still maintaining compliance with the FLSA. Now, keep in mind, I just covered this at a super high level. There's always a lot of additional nuance that goes into dealing with federal and state regulations. There's also some industry specific stuff that I haven't covered. There's additional exemptions in, say, agriculture or the railroad industry. They can have some additional factors that would come into play. That said, given the recency of the case, it might be worth taking a look at your current salaried employees and making sure that they truly are overtime exempt. Like I mentioned before, the DOL's FLSA advisor is a great first step in verifying that they have the job responsibilities that meet the requirements. From there, you can look at your policies, processes, procedures, make sure your pay structure is in line with the expectations of the FLSA and state regulations. And as you begin this review, I mean, we'd be more than happy to assist with any questions you have. If it's your first time working with us, just reach out to Elizabeth and she can get you connected with us. That said, like I covered at the beginning, we're still kind of waiting on that DOL overtime rule that's eventually going to come out at some point. But it's still a good idea to get in compliance ahead of time instead of waiting for potential regulation changes that have already been delayed multiple times. So with that, I'm going to go ahead and turn it over to Amanda. She's got a pretty interesting update on FMLA.
Thanks, Mitch. And before I jump into that, there are a couple of things Mitch touched on that roll nicely right into what I've talked about and just your experiences in working with Ironwood. So the first, as Mitch talked about, and we have been talking about literally for a year now, those overtime exemption changes. The last we have heard that is slated for this summer to get that sometime between May and July. Again, I would just caution no one to panic. There will be a considerable length of time before the change is proposed, before it goes through feedback, and before it goes into effect. It was more than 2 years the last time this changed, from the point at which we got the original proposal to when it went into effect. So although we want to keep it top of mind, as Mitch said, it's great to go in and check now. Even once we hear something this summer, there's probably going to be tweaks and changes. But what I really like between what he was talking about, this next case that I'm talking about with FMLA, and just a lot of our conversations that we have with you guys together, is the really nuanced differences between the language we sometimes use. And it might be more subtle if you mostly communicate with us over email, because a lot of times, rather than sending 20 emails back and forth, sometimes we do that, but we just jump right into the language that we assume that you're talking about. And Mitch hit on this. A lot of times, most common would be things like salaried and exempt. You guys will call it and you'll say, well, this is a salaried employee. And we'll turn around and say, but are they exempt? Or you mean exempt, don't you? So that was a great example that Mitch provided. Another one of those things, if you've not talked to us before, or if you have and we haven't explained that rolls into this next case, is a lot of times you'll jump on with Mitch or I or another person here at Ironwood, and we'll start with what's going on. And you give us this little rundown. And then more often than not, we take 8 steps back and say, okay, great. Let me ask you a few questions. How many people work for your employer? What states do you operate in? Are those people spread out or in home base? And we're normally pretty good about explaining that we ask those questions to try to figure out which regulations apply in this scenario in particular. But if we didn't explain that, or if you didn't remember why we changed course on you entirely or in the future, that's why. A lot of times these regulations, whether we're talking about ADA or FMLA that I'm jumping to, are set by the number of employees that you have. So one of the things that, again, I want to say was all over the news and all over my LinkedIn and feedback, but that's probably because our algorithm is all about HR and employment law for us. So maybe it didn't go to everyone, was about a recent decision about FMLA. So the question overall was, and what made headlines was, that employees could indefinitely reduce their work schedule under FMLA. And that was kind of the shock and awe headline. Now, of course, once you get into more specifics, it's not quite that specific. So the actual wage and hour division published a letter in response to an employer's question. So I will back up and say, even though we've had FMLA for about 30 years now, these sorts of public responses in letter form are not entirely common in the FMLA realm. A lot of times we hear interpretation letters if you're talking about OSHA, or again, sometimes if we're talking about regulations, we talk about the interpretation of a court ruling. This was an actual letter published. So this is pretty unusual. Again, that is one that does seem to change with administrations, but it's been probably 15, 18 years, I think they said, since the last one was published on this topic. So the original question that the employer wrote in to Wage and Hour was asking whether or not they could in fact limit an employee's workday to 8 hours indefinitely because of a chronic health condition. So the best way that I could put that into life now or the very recent past would be, let's say somebody had chronic or a severe case of long COVID or a very serious case of COVID, and they were released to come back to work, but the doctor said they could only work 8 hours a day. And if you work a regular exempt position, a lot of times your work weeks are rarely 40 hours. They're often 45, 50 hours. So this specific employee individual, the doctor came back, I'm using COVID as the example, but it's not necessarily, it could be any chronic health condition. Doctor came back and said, fully released to work, except they can only work 8 hours a day. The employer then went on to ask, is this a situation where FMLA applies, or is this a situation where ADA applies? And this is where things start to get sticky and sometimes confusing with all of the acronyms, and again, with which laws and regulations come into play. So in the letter itself, again, like I explained, that a lot of times exempt employees are just expected to work more than 40 hours. This individual in particular did have, let's say, have to normally work 10-hour days. And so it was going to present a shift problem if they could only schedule them to work for 8 hours instead of their normal 10 hours. If they weren't going to have adequate coverage, which could present safety issues, it could have business interruptions, there could be some major side effects to this change and requirement of this employee, and then potentially assuming if other employees had that in the future, to their business requirements. So the letter came back and said they would be, as an employee, if they were eligible, entitled to reduce that schedule to 8 hours. And in this specific case, they said this was because of an FMLA qualifying reason. So let's pause there and let's make sure we're understanding what FMLA is. So FMLA, Family Medical Leave Act, it applies to employers with eligible employees. You're going to see some of these words like eligible, some of our favorite words that have more definition and nuance and meaning than we'd like to recall, with more than 50 employees. And the way they figure that 50 employees is based on 20 work weeks of the prior year. So if in 2022 you had more than 50 employees for at least 20 weeks, that would be considered that you're over 50 now. Same into this year. I was just doing a look back period there. So if more often than not, or the majority of the time, you have 50 employees, assume that it applies to you. There's also some regulations in there as far as where those employees work. And so that's another piece that's been changing, and we're going to touch on that here at the end. But generally, it's if your employees work within 75 miles of each other. So if you have lots of little satellite offices that are maybe around a metroplex, if they are all within the 75 miles, you're considered the same business. If an employee has been with the company for more than 12 months, and in that prior 12 months have worked 1,250 hours or more, that's another one where if we get really into a situation where we are hashing out the specifics of an ADA case, a workers' comp case on who is eligible for FMLA. That is one of those things. Sometimes if we've heard, let's say that employee has only been there 14 months and there's been some ongoing health conditions over the last year, and let's say they didn't qualify for FMLA because they hadn't hit that 1 year requirement, but you allowed them to take some unpaid personal leave, or maybe that employee started as a part-time employee and then later became a full-time employee. There are some situations where somebody could hit that 1 year, that 12-month mark, and not have worked 1,250 hours in the prior year. It's also hours worked. So if you had a ton of even paid time off, that could also affect it. But again, normal year, you work just over 2,000 hours if you're doing a 40-hour work week. So I think it comes down 27, 28-hour a week average. So sometimes if you have the software and the system to go back and actually run those numbers, it's just something good to check to make sure they've worked that 1,250 hours. So the employee's been here for a year, they were full-time, they met that 1,250 requirement, you have more than 50 employees within your area. Okay, FMLA applies to you. This is not optional. So we were on a call recently and going through a workers' compensation case, and the response, and it wasn't meant to infringe on anybody's rights or to even egregiously violate, any sort of Department of Labor protections. They're like, well, we don't have FMLA. That's not something we do here. Okay, and then again, we circled back to, but where do you operate? How many employees do you have? Everybody's within that area. Well, your employees are eligible for FMLA if they're full-time. So even if you've never offered it before, it doesn't mean it's not something you shouldn't be offering. So keep that in mind. If you are over that 50 mark and you don't have an FMLA policy, or if you are not familiar with some of the things that we're talking about, this is new, or you say, oh, well, we've never had anybody get sick before. We get that answer a lot too. Well, nobody's ever needed it. Sure, that's possible, but more likely than not, someone over the course of your company's business, if you've got more than 50 people, someone had a baby, someone had to have surgery, somebody's family member had to have time and they needed job protected leave time off. And that's the difference there. So when I talked about the personal leave earlier versus FMLA at that 1 year mark, the difference is FMLA is job protected leave. So employees are eligible for up to 12 weeks of job protected leave. This FMLA leave has nothing to do with short-term disability or long-term disability. Those can run concurrently, the short-term and FMLA. It has nothing to do with whether they're on workers' comp. Those could also run concurrently. So just because someone is in one category doesn't mean the other one may not apply. We'll get sometimes, well, they're on short-term disability, so we don't need to put them on FMLA. Yes, you do for a certain period of time. So some of the things that were also discussed in the letter that we want to bring up, as I mentioned, the question itself asked, so let's say this person had long COVID. Again, normally they're working 10 hours a day. The doctor said you could only work 8 hours a day. The employer was knowledgeable about a lot of rights for employees and said, well, wouldn't this be an ADA accommodation? And again, accommodations is one of those things we probably talk to you guys more about than FMLA because it applies to more people. It applies to a much smaller company size. So if you're down in that under 20, over 14 mark, that's your group where it's kicking in, and everybody above that. Wouldn't that be an accommodation? So other than job protected leave under FMLA, it is an accommodation. And the difference there is job protection is as long as the paperwork is completed, the doctor has signed off and said it's medically necessary or whatever the situation may be, you don't really have a ton of choices as the employer. Versus ADA accommodations, there is that language that we've talked about before about the suggested accommodation has to be agreed upon by both parties. The employer has to show that it doesn't cause a business disruption, that it is reasonable, that it can be done safely. So it's how strictly you would need to abide by that if there was a real business reason you couldn't accommodate the request under ADA versus FMLA. So in this situation, again, the employer qualified for FMLA. So the letter came back out, responds to the employer, and cautioned, ADA and FMLA can actually occur also at the same time. But in this particular case, down to the question of, could that work day be limited down to 8 hours? Yes, it could be protected by FMLA. So what would that look like? Because most of the time, and as I've highlighted already, we are talking about 12 weeks of job protected leave. Okay, seems pretty straightforward, right? When it normally gets a little trickier is if it's not 12 straight weeks. I'm not having surgery tomorrow and I'm going to be out and see you guys in 3 months, and then I'll be back and I'm out of FMLA leave for the year. Those are traditionally a bit more straightforward. It's easier to plan for that. More often than not, we have equated that to 480 hours. And what this latest opinion letter really clarified is, especially for those exempt employees that work more than 40 hours a week, that it may not equal 480 hours. So let's pretend we're not going to have surgery and just be out for 12 weeks. Let's pretend somebody was going to have a surgery. They did all the paperwork. They gave notice in advance, model employee, going to be out for 4 weeks all the way. And then when they come back at week 5, maybe they only can work 4 hours a day. So they might be using 20 hours a week of FMLA. That would be our normal interpretation. Or we might only need partial days, or what we call intermittent FMLA. Again, as I just caught myself there saying, the hours itself is the main component of this case and of this letter. Because if that person, same person, had the 4-week surgery, coming back, doctor says you can only work 4 hours a day. If that person on average worked 50 hours a week, then they might need to apply 6 hours of FMLA in addition to the 4 hours they can work each day to meet that 10 hours. And that would also mean that the number of hours of FMLA that they eventually hit, in this case, because we're using 50 hours times 12 weeks, could be 600 hours versus that 480 number that we normally have in our head, because again, 40 times 12 weeks. This was really acknowledging that there are a lot of people that work more than 40 hours a week. So more specifically in this case, the example that I used, used the extreme of 4 hours versus that, but this was, just using 2 hours at a time. The employee could only work 8 hours, remember, regularly scheduled for 10, eligible for FMLA. So every day they were plopping in 2 hours of their intermittent hours. So on this example that we're using, 2 hours a day, again, normally works 50 times 12, 600 hours, 10 hours a week. That would go on for the full course of the year. So it could look like an indefinite ending to how long this employee could use those FMLA hours. And essentially, the letter said that could happen. As long as they continued to remain eligible, so they met those hour requirements for the next year, the doctor was continuing, or the medical professional was continuing to say that it was necessary, that number of hours could actually be considerably greater than 480, especially in those situations of intermittent leave. So again, partial regulations, sometimes also people, back in our surgery example, might come back and then they just are going to have to go to PT twice a week. So they might just need a couple of scheduled appointments here and there, maybe a couple extra doctor's appointments, or if they're caring for someone with an illness, it might be more sporadic than these straight periods of time. But that total number of hours that you normally manually have to keep on a spreadsheet when someone goes out on intermittent leave, needs to be based on their average work week. And that could be very different for one employee versus another. If one department generally works, yes, they're exempt, but they're generally more, 45 hours a week, their number of average hours is going to be different than an department that averages, or an employee that averages 50 hours a week. So knowing that number and having the capability to go back and run those hours may become increasingly important. Again, in the letter, as I touched on a few minutes ago, it did point out that ADA and FMLA were not mutually exclusive. So there could be situations where the other would apply. Or if that individual, let's say we're back to the needing to use 6 hours a day. Doctor only said they could work 4 hours. And they do actually run out of, in our example, 600 hours before the end of the year. You still may need to work with the employee after they run out of their hours for an ADA accommodation versus the FMLA leave. And again, I know we're throwing around a lot of acronyms and it does get confusing. Again, more often than not, when we're talking about these things with you guys, we're also throwing in a workers' comp component, which just makes things even more complicated. So I know it's a lot to follow, but to kind of recap and focus again on the basics versus exactly what came out in this new letter. The entitlement for those that are eligible is 12 weeks or that 12-week equivalent, and focusing on that versus our standard understanding of 480 hours. Again, first public opinion letter released in years on this topic. The 12 weeks, I don't think I made a point to say this, and this is often confused under FMLA. Although it's job protected leave, it's not necessarily paid leave. Sometimes that makes employers and companies nervous. They hear FMLA and they assume that it's paid leave. It's generally actually here unpaid leave, especially here in Texas. Again, paid leave could change. Mitch hit on some of those things earlier, state to state. So keep that in mind as well. But you might have a specific policy in place under your FMLA policy or within your handbook that says whether or not you have to use paid leave. That's pretty common, what we recommend before unpaid leave. Again, all of these things could be going on at the same time. Somebody could be out on workers' comp under FMLA. You might also have to consider an ADA accommodation when they come back, and then continuing on and down the line, let's say the workers' comp case closed and there were still other things going on, you could still be looking at short-term and long-term disabilities. The key things to remember there is these things are rarely mutually exclusive. Sometimes they are operating at the same time, and that's where especially it's probably time, if you're not familiar, to give us a call or to go back. And a lot of times the policy is in your handbook, but if you haven't had to use it in a long time, or it's just not something you're familiar with, you probably have something nice in place that spells all of these things out, but you're not reading your handbook every day, you may not know that. So that's where we normally point you to first, is what do your actual internal policies say on this? Because even though there are some requirements under the federal part, there are some things up to you, and that could be how health insurance is paid, who do they go to talk to about this. There are also some other changes. A lot of times we speak generally about FMLA and say, I even did it earlier, about the birth of a child, but more specifically, it could also be adoption. It could be foster care. There are some differences in the amount of leave that can be taken. Let's say a family has a child and mom and dad work there for you as the same employer. Their entitlement may only equal 12 weeks total, depending on the situation, versus 12 weeks for each one of them. So there's all these little nuanced responses, again, a lot of times that are written into your policy. Who you can take FMLA to take care of is also another one of those areas that is specifically outlined as far as what qualifies as a family member, that we could get into the nuance there. also what serious health conditions are covered and how that would affect your ability to perform your job. Those are all some of the things that we would need to talk through again, or that you would want to look for in your policy or as you're writing a policy on these. Another thing I want to point out with FMLA too, that will come up less often, but should be in your policy, is if the leave, either for yourself or for someone in your family member, is related to active service. So somebody's called to active duty, a spouse, a child is injured in line as a natural guard, excuse me, let's reverse there, is injured while in active duty status or is part of National Guard or the reserves, they actually qualify for more than 12 weeks in some of those circumstances. So that would just keep that in the back of your mind, that if we're talking about someone that is out of work, or family member is out of work twice serving, keep that as the asterisk in your mind of, okay, I remember something else applied here. I need to go in and do a little bit more digging on that. So there are all of these little nuances, but we covered the main components of FMLA of itself. If you don't have a policy in place and you are over that 50 employee limit and anticipate staying there, at least for some time, it is a good idea to make sure that, sorry, I completely just lost my train of thought. It is a good idea to make sure you do have a policy laid out. Although there are some components that are required, there are some things like the 12-week period in which you can use that could be determined by internal policies. You have 4 choices and you set that out in advance. It doesn't change. It's, you can use 12 weeks of FMLA. Some people do it based on the calendar year. Some people do it on a fiscal year. Some people do rolling one direction or another. So that is laid out in advance. And is put into your policy. So if it's not something you've added before, that's something we would want to talk about and you'd want to think through which makes the most sense for you as a company. And it's also just something you want to be aware of, because a couple of times, more often than not, it's a rolling 12 weeks as from the year prior to when they go out. That's what most companies do. But every now and again, we'll see somebody that's running on an anniversary year or a calendar year. And because we didn't go back and check the policy, we've had to come back and change the outcome or make some minor changes and recommendations. So whether we're talking about FMLA or anytime we're answering a question for you guys, a lot of times you will see the default answer, or you'll hear Mitch or I or another member of the team go back and say, now, but please make sure to go back and check your internal policy, because we can talk about general regulations all day long, but you may have some nuanced language and you want to make sure that you are either following that or making revisions and updates so that you as a company will be consistently following it moving forward. Because, that's our big thing with policy. Don't just have a policy for the sake of having policy. It needs to be applied consistently, because otherwise then we could spend a whole nother hour talking about potential discrimination issues. So again, I know that was a lot of information today, a lot of acronyms. I feel like maybe the most acronyms we've ever used in a session. But if you have questions, of course, we're always here to help answer those, whether it be about the extended definition of 12 weeks for FMLA or any other things we covered today. So that, I will hand it back to Elizabeth.
Thank you both so much. Always such a wealth of knowledge. You did great, though. You didn't really get tongue-tied on any of that, so I'm impressed. But yes, as Mitch and Amanda both said, feel free to reach out to me. If you don't currently have an agreement in place, I'd love to get you signed up so you have access to Ironwood's wonderful team. But wishing each of you a wonderful spring break, and we will see you back here in April. Thanks so much.
Guys.